Family law is about people, not paperwork. Trusted by thousands of UK firms, Leap's legal software gives family lawyers a single, fully integrated platform to scale your practice, stay compliant, and deliver better client outcomes. Learn more at leap.co.uk.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today I'm delighted to welcome on Rachel Cohen. Rachel is a director at the Intermediary Cooperative. No prizes for guessing. The topic of conversation, therefore, is intermediaries. It's a topic that we've covered on the Today's Family Lawyer podcast previously, but it's a good couple of years ago now since we last did it. And so I thought it was very worthwhile revisiting it and talking about perhaps how the role has developed and what the impact of some of the court's challenges have been on the role as well. So thanks very much indeed for joining, Rachel.
Good morning.
Very brief introduction to you. I know you've been an intermediary for quite a number of years and you've had a couple of roles within the Intermediary Cooperative as well over that time. But tell us a bit about yourself and your background in the first instance, please, Rachel.
Okay, well, first of all, thanks for having us on, David. It's a great opportunity to talk about the work that we absolutely love doing. So, yeah, my name's Rachel. I'm a communication specialist. So I work as an intermediary. I work across all sectors, really. Family, criminal. I work with witnesses, parents and participants in family courts, and with defendants. I've been doing this job for about 12 years, working as an intermediary. My background, like many intermediaries, is speech and language therapist, but we do come from different backgrounds: psychology backgrounds, specialist teaching backgrounds, probation sometimes. So yeah, I work mostly in family courts. That's where I spend most of my time as an intermediary. And the role really is just essentially to help the court understand a person's communication needs and help a court understand what adjustments might be needed to ensure that they can effectively participate in the process.
And important to sort of note, it's a non-legal role, isn't it? Although you have some understanding of some of the legalities of the process, and it's perhaps necessary as part of the role, at the same time, you're not there to interpret for the person, are you, at all?
No, it's a really good point, actually, David. We're not there to give legal advice. We have training around the law and processes, but we are definitely not there as a legal professional. We're not there to give advice. We're not there to give evidence either. Our role is not to influence any outcomes of the case. Our role is really, really narrow and very specific, and actually quite a practical role. We're often, when we're assessing communication and looking at what measures could be put in place, often they are really, really practical measures. So yeah, the role is impartial. We're an officer of the court and simply there to ensure that everybody understands what a person's communication needs are and how most effectively they can interact with that vulnerable person to ensure that basically they're able to participate, understand and be able to communicate their instructions.
I guess the kind of key question for me and perhaps for listeners to the podcast is, when is an intermediary kind of appointed? When is it needed? And how do we identify when it's needed as well?
Well, I suppose one of the most important things to say at that point is the earlier the better. It's much more effective if an intermediary is instructed quite early on. So in terms of identifying when somebody's vulnerability would suggest that an intermediary assessment is good practice, what you might be looking for is things like a person who is agreeable, but perhaps goes away and then sends lots of frantic emails asking questions, which might sort of might indicate perhaps they haven't understood everything that they've said they'd understood in conference. Somebody who's not able to explain or give instructions, or if there's lots of inconsistency isn't necessarily somebody not being honest. It could indicate difficulties around sequencing, narrative, explanation, understanding time, concepts, that sort of thing. Perhaps somebody who's very literal in their interpretation when asked a question. Perhaps somebody who's becomes quite dysregulated or overwhelmed, tearful, can often indicate that actually there's something else underlying there that may require an assessment, at least by an intermediary. And an intermediary, once they've assessed, if we don't feel that their communication needs warrant any assistance at court, then we would suggest that actually they don't need the assistance, but at least you've had an assessment where someone's looked in great detail at somebody's communication to make that decision of whether actually that they would benefit from assistance at court.
Hesitate to say it, but there's this real kind of buzzword around neurodiversity, some of the challenges that brings with it. Is this a role that obviously supports those with neurodiversity, but also, I guess from what you're saying, it's not unique to people who might face some of those communication challenges?
No, absolutely. Neurodivergence is a buzzword at the moment. It's not new to communication specialists because it's something we've worked with for many years. But I think there's really a greater awareness in the courts now about what neurodivergence is, and actually the breadth of actually what that affects for somebody with those sorts of needs, how it impacts on them, on their communication. But it's not just neurodivergence. We work with brain injury, head injury, with developmental language disorder, people who have maybe selective mutism, and difficulties that are very situation specific. One person might be able to communicate fairly effectively in one situation, but you put them into a court setting where, stress levels are high, anxiety is high, they may perform really differently with their communication, and the needs may be much more highlighted and apparent in a court setting versus when you're in conference with somebody.
What brought you into this particular sort of sphere then? As you say, you started out speech and language therapy, but this is, I realise it's an extension of that, but it's quite a departure from somewhere like the NHS, for the sake of argument.
Yeah, interesting question. I get asked this quite a lot, actually. So as a speech and language therapist, right back when I very first qualified, I was put into mainstream secondary schools in Leeds, middle of Leeds. And the challenges for young people in secondary education who had communication needs just fascinated me. And actually the link between communication difficulties and criminality. So I know we're veering on to criminal courts here, but it's around 70%, 65 to 75% of the adult male prison population have a speech, language or communication need. So as a young speech and language therapist, very early on started working with teenagers and started then working on the edges of youth offending teams, and it led me really nicely into intermediary work. Because as a speech and language therapist, I could see what their needs were. I could see what sort of treatment plan they needed, but could see that support and assistance wasn't necessarily there or followed up when they really crucially needed it, when they got in trouble.
I guess, and I don't want to put words into your mouth, Rachel, but that feels as though taking somebody through a process by which you support them through some of their speech and language developmental challenges against, a role in which you're, dare I say, a bit of a one-hit wonder, that must bring with it its own challenges as well, because presumably, again, you're only working with litigants for a short period of time.
Yes and no. What I find in family courts is actually your involvement with a client is slightly longer term than it is perhaps in criminal proceedings. And, quite often I've been working with the same client over a couple of years, particularly if they've been in family court with one matter, and then they may eventually end up in family court again with something slightly different. So it is different because you're not there for you're not there for treatment planning, you're not there to rehabilitate in any way. The role is really, really different, but you're drawing on your skills in terms of understanding communication, understanding vulnerability, and understanding what accommodations and changes people can practically put in place to enable somebody.
You talked in response to this discussion we had about neurodiversity, about the courts recognizing it better. I mean, it's always been there, as you say, but there's a better recognition in the judiciary of some of these challenges. Do you think there's been a changing attitude towards the role of intermediaries in the years that you've been practicing?
Yes, I do. There's definitely a better understanding of what the intermediary role is. Mm-hmm. Absolutely. And there's some absolutely fantastic practice out there and some really effective relationships that lend themselves to really, really great working practice. But there's also changes around, because we've been here a little bit longer and people are used to working with us, and perhaps there can be some assumptions that form. And I'm thinking things like not being invited along to ground rules hearings, say, in some courts, routinely not invited to ground rules hearings. Because the understanding is better, there are assumptions that actually, the courts and lawyers can do that without an intermediary's input. But that's the very, very time where intermediaries can have the most impact at a ground rules hearing. It's a brilliant time and opportunity to plan, basically, to make adjustments for somebody. And actually, when we're not invited to ground rules hearings, we can be there then on sort of a fact-finding hearing at the start of it, having not been to the ground rules hearing and not actually understand what's been put in place, or not be informed perhaps of what decisions have been made. So we can be kind of kept out of the loop a little bit. So there are these brilliant changes in terms of understanding role, but then with that comes this assumption that actually we perhaps that people might know what's going to be talked about, so perhaps not inviting us along. So
what do you see that some of that change has had in terms of your ability to support clients and support users?
I think so. In my experience, sometimes there are much higher level conversations with legal practitioners because their understanding is at a higher level, which gives us the opportunity to be able to kind of think even more outside the box sometimes, and to have a better conversation about how we're going to enable somebody to participate. But also there are conversations that are a little bit more tricky sometimes, because perhaps we haven't been at those conversations, so we're not aware of potentially where the conversation is up to, what plans have been put in place, that sort of thing.
Given all of the kind of funding issues within the judiciary, and I know this is a tricky topic to navigate for you guys, but do you feel as though funding is an issue for your role, and therefore the judiciary suffers as a result of being able to instruct you, or what's your kind of general feeling around some of those issues?
Well, I think the pressures on funding and court resources has undoubtedly had an impact on how intermediary assistance and support is approached, and that goes right across the system, really. But I think there can be a tendency to see intermediary involvement perhaps as an add-on rather than part of the range of participation measures available, an added luxury as opposed to actually, a real core necessary function and role. I think the difficulty with that mindset is that if there's a delay in the recognition of a communication need, or a delay in instructing an intermediary, in my experience, it can lead to a lot of inefficiency later on. If we've got somebody whose vulnerability is around perhaps their emotional regulation and stress, post-traumatic stress disorder, something like that, I've experienced it where hearings have had to be adjourned, sometimes for a matter of days or weeks, or even gone off for months. So where they, from the outset, the aim has been to perhaps save and make efficiencies in the long term. Actually, there isn't any cost effectiveness because it has led to the lack of an appointment of an intermediary can sometimes lead to wasted time in court.
One of the things that I'm really struck by with roles like this, and I'm thinking about intermediary roles, I'm also thinking about people who do things like divorce consultancy, is the level of qualification and training that goes into them. And I'm not saying that for you to take it the wrong way. I'm saying for that legal professionals should really have confidence in these roles and the people that fulfill them, because number one, they play a really, really important role, as you said, in helping clients through the legal process, but also they're hugely helpful to the practitioner as well, aren't they? I mean, as we move towards the end of the discussion, I really wanted you to share some best practice and ideas on how the legal profession better interacts with and works with intermediaries.
I think the best working relationships often happen when the intermediary is seen as part of the participation framework, not as an outsider just brought in as an extra layer. I think lawyers get most from intermediary involvement when they engage early. I think it's really, really important, because what we have found in the last couple of months is lots of very, very late last minute referrals for hearings that are happening in the next week or the next 2 weeks. And if you think about the role of an intermediary, we need to build rapport with somebody with vulnerabilities. We need to be able to assess them. We do have an assessment window, but assess slightly over time as well, because communication can fluctuate in different situations. So being able to be there early on in proceedings is really, really helpful. Sharing as much of the background information as you possibly can with us. Not just the cognitive assessment if there is one, but actually sharing the threshold right up front, so we can really understand what the sort of issues are in a case. Having an open mind. Quite often we are people who are pushing the boundaries a little bit in terms of what you might think a hearing should look like as a practitioner. And intermediaries are often sort of suggesting something maybe a little bit different, sometimes really radical. I've sort of suggested that therapy dogs come into court and things like that, which, I think as an intermediary, we're just asking that you have an open mind. We won't be recommending something without like a really good reason behind it, which is well thought out and comes from an assessment. To understand as well that we're not there to criticise anybody's communication style. We are there to enable and to facilitate communication. So sharing documents with us ahead of time, and don't be offended if we simplify and shorten, a 20-page document into one side of A4 bullet points. Again, we have different roles in the system. A lawyer's role is very, very different and broad reaching. Our role is very, very focused and narrow. It's to simplify and to make things accessible. So sharing those documents with us so that we can, take submissions perhaps and simplify them into bullet points for a client. Sharing the judgment with us and asking for the court's agreement to share a judgment with us when it's in its draft form, again, so we can simplify that so that it's accessible for somebody who may have a concentration span of 5 to 7 minutes, and a judgment maybe, a couple of hours. If we have that early enough, we can simplify that so that we can go through it with the client in a really, really simple, easy, straightforward and slowed down way. Coming back to your question though, I think in terms of how to get the best out of an intermediary, it's to engage with early, to have an open mind, to view us as a resource for the court, and to remember that we are, an officer of the court. We're not on a legal team, so we're not sort of on anybody's side, so to speak. And to make sure that we have dates really, really early. because it's a real bugbear, and we like to work with the same client. It's one of our sort of key components at the Intermediary Cooperative. We see through from the very initial assessment right through to the end of the case where we can with the client, same intermediary. And if we have dates really last minute, it can be very challenging for us to cover them.
It's been great to have you on the podcast, Rachel. Thanks very much indeed for coming on. And as I said, we've talked about intermediaries in the past, but it's always worth a refresh. So really appreciate it. I know, for example, that the Intermediary Cooperative does quite a lot of outreach as well and work in terms of some of those points that you've made there around best practice and some upcoming webinars as well.
Yeah, we do. We offer what we call a lunch and learn session to all solicitors and chambers that we will deliver. We'll come out and deliver those in person, online, and they're brilliant opportunities actually to learn in more detail than I've covered today what an intermediary is there for, how best to use them, how to engage with them, talk you through the process and that sort of thing. And they're offered, we say lunch and learn, but we do offer them sort of at twilight sessions and things like that as well. That can be a really helpful thing to do. We've got some training coming up as well, so keep an eye on our LinkedIn page and through the different publications, because we are putting on some CPD sessions, which are really, really valuable, about vulnerability and about access, neurodivergence. There's a range of topics that we're going to put into those, so definitely keep an eye out for our training.
Fabulous. I mean, it's a whole different podcast to start talking about vulnerability, how we identify it. I know you've tried to do it a bit of justice over the course of today's discussion. So thanks very much indeed for joining.
Thank you for having us.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Rachel. Thank you as ever for listening, and we'll see you again soon.